Mufasra Khalid.
Successfully joined us, so thank you for that. I'll just check that Mr. Ahmad is now available. Mr. Ahmad.
Your Honour, can you hear me? This is Umar Ahmed on behalf of the mother. Your Honour, yes, the mother has tried to make contact with my throwing. Oh, excellent, good.
I think that everybody's in. So, usual ground rules, please. This is a court hearing, although taking place by telephone. It is a court hearing. That means a number of things. Firstly, that nobody other than the advocates, the professionals, and social workers, the guardians, and us should be able to overhear what passes during the court of this hearing today. Secondly, because it's a court hearing, it's recorded by the court purposes, but should not be recorded by else. And thirdly, can I ask that when anybody's talking, everybody else mutes themselves, please, and don't interrupt everybody else talking. It's a matter of urgency, as otherwise we get feedback and it becomes very difficult to follow what's going on. So if anybody needs to say anything, then of course I will come to them. So those ground rules all apply. I'm just going to lock the meeting and then commence the recording. So just bear with me a moment, please.
Conference is now locked. The conference is now being recorded.
Right, then I have read some of the battle, not all of it. Time to read. I've read all of the current material and the judgment and the orders binding on the judge's part. I've read the position statement that have been submitted to me. So I think probably over to you firstly, Mr. Ahmad.
Thank you, Your Honour. Yes, indeed, this is an application on behalf of the mother for leave to oppose a placement order that was granted me on the 16th of December 2019. Your Honour has pointed out that the position statement has already been read, so I won't go into the law unless Your Honour wants me to go through it. Thank you, Your Honour. And the court kindly allowed my client an opportunity to put together a further statement to add more detail to her already filed statement, which is within the bundle. And the mother has done that pursuant to the previous order. Your Honour, the way I wish to address the court in respect of the mother's progress since the conclusion of care proceedings is under the same headings as you find in the document that was filed on her behalf. It is respectfully submitted from the outset that the mother's changes are significant, and that being higher than the law where it states that, in fact, it doesn't need to be at such a level, doesn't need to be as high and significant, but it needs to be of a nature and degree sufficient to open the door to a consideration. And on that basis, on that footing, I've addressed the court on the main heads of her application. The first, which I would submit, is one of the root issues in respect of her mental health, in respect of her presentation to professionals, and of course in the way previous proceedings had unfolded, and that is her drug use. The mother has, to her credit, since the conclusion of previous proceedings, dealt with the issue of cannabis use. She's no longer smoking cannabis, no longer taking cannabis, and that is proven by the hair strand test results that she has filed within the proceedings, and that was done at her own cost. This was done prior to her obtaining legal aid and was something that she had addressed herself. So she has dealt with the issue of drugs, and that, Your Honour will see, was a very significant issue in care proceedings. At B3, it says in the order of the 16th of December that the mother does not accept that her cannabis use is a problem. Well, she's recognised that now, and she's addressed it. And she does not accept that it would interfere with her current medication. And she is not even at the stage where she can appreciate that things need to change. I'm addressing paragraph 11 of my document, where it refers to the order of the 16th of December. The issue of drugs was also raised by His Honour Judge Clark in his judgment, and I refer to that as paragraph 58 at B28, where His Honour Judge Clark states that the mother does not accept that cannabis is a problem and refers to it as her medication. Well, the mother has shifted from that position. She's no longer treating cannabis as medication. She is sticking to what the experts have told her, and I will address you on that later on in my submission. She hasn't touched cannabis, hasn't been tested positive for cannabis use since December 2019. There was a link suggested by the psychiatrist, Dr. Sargent, in the psychiatric assessment, paragraph 37B21, where there's a link between the cannabis use and the ability of my client to manage her medication. Sorry, it would impact on the medication that was trying to manage her mental health. You see, now that the issue of cannabis has been removed, my client has been able to focus on what is her mental health difficulties and has made progress dealing with her mental health. The points, the efforts made by my client to deal with the cannabis is confirmed by her engagement with Turning Point. My client exhibits that as Exhibit D in her second statement. I appreciate, Your Honour, that it may not be included in the bundle you have before you, but I hope you have a copy of my client's statement before you, and to that is attached Exhibit D, a letter from Turning Point. It's dated the 29th of June 2000. I would submit that that's a very recent letter, and the letter in itself, A, confirms that my client self-referred herself to this organisation, and B, that she has completed the work that she was required to complete. The self-referral reflects the motivation that my client has to fix the issues before her, to address the difficulties that she has, to deal with it head-on, to engage with these services, and then to focus on the cause that was provided. And ultimately, she was discharged from Turning Point in February 2020, having successfully completed a course. She took on 12 sessions. They focused on triggers, coping mechanisms, and stress management. And now my client feels that she is better equipped, A, without the drugs, and B, being able to deal with the issues of stress and to be able to manage herself in situations where there may be difficulties.
Whilst I don't seek to underplay the importance of mum attending that, of course the final hearing was December 2019, as you say, she self-referred in June 2019, so the court was clearly aware of that self-referral at the time it made the findings it did, wasn't it?
Indeed, Your Honour, but this is now what I would say. There is a change of circumstances because she has seen herself through this process and is now in a position of having completed it and having now abstained from cannabis. So she's not just abstained, she's also completed the course, the therapy that was involved with the Turning Point. And as I said earlier, I would say that the cannabis use and the mental health difficulties are intertwined. She has now untangled the issues of the drug use and has now had the opportunity to focus on her mental health. She was discharged by crisis, and that's exhibited in the bundle. But I apologise if it also noise. There is a building site next door to me, unfortunately, and there is some noise creeping through. Thank you. And Your Honour, you see, there's a letter dated the 11th of July from the crisis team, which states that the mother is to continue to collect the medication from her GP and to continue to engage with Turning Point. Well, we know that she's successfully dealt with Turning Point, and I am instructed that the mental health is stable. She hasn't had any recent episodes of mental health difficulties. She continues to collect her medication from the GP, and there is already discussion with the GP of a reduction in the medication that she takes because of the improvement to her mental health. And so she's dealt with the recommendations of the mental health services, and she's open to conversations and advice from professionals, including the GP, and there is hope that the medication that she takes can slowly decrease. Your Honour, another difficulty that my client faced in previous proceedings was the fact that she was at home and that Mana was exposed to difficult family dynamics in the family home. Of course, my client has secured alternative accommodation. That accommodation, I understand, was there at the end of last proceedings, but it was new. But she's managed to maintain this accommodation. She still lives on her own. And there haven't been any difficulties with her family. There's no family dynamic is interfering with her way of life. And if anything, she has gained positively since living away from her family. So I would submit that that's another factor proof that there has been significant improvement in my client's recent circumstances. Your Honour, if I may just turn to I just noticed that one of the windows was slightly ajar. I've just shut it now. Your Honour, the order of the 6th of July 2020 required the mother, my client, to address the points that were raised by His Honour Judge Clark in his judgment at the close of the proceedings. And Your Honour, if I may just refer you to that, that's at B27, and I apologise, I think this section was under care. But paragraph 55, it discusses, paragraph 55 makes findings that my client would raise her voice during proceedings and interrupt witnesses, and at times she'd become abusive. This was a very difficult time for my client. At this stage, there were care proceedings, there was drug use. So it was a difficult time for my client, and the fact that the local authority was seeking an application to remove Manha from her care placed her in a very traumatic situation, and therefore I would submit that my client behaved in a manner which the court would not be unfamiliar with when having parents being faced with the possibility of a child who they've raised for a number of years to be removed from their care. And this was a mother who was very, very desperate at the time. The paragraph 56 relates to my client's mental health, and it does state that my client had a psychiatric relapse and that she was fighting to retain her daughter and that she clearly loves. Indeed, my client's mental health is now stable. She was fighting for the daughter she clearly loves, and that was the reasons for her heightened emotions. That was the reason for her Manha is her life, and she will do whatever she can to try to ensure that Manha is in her care, in her life, involved in her life in some form or another. So my client did fight, and she fought it to the very end.
Mr. Mike, as you refer to Mum's mental health, the only evidence I have of her mental health post the conclusion of the proceedings is her self-report, isn't it? And again, unfortunately, and of course I have immense sympathy for her in wanting Manna back in her life. I'm sure we can all completely understand that. But the court didn't accept her evidence in the previous proceedings, and the only evidence I have in relation to her mental health now is her own, isn't it?
There isn't anything other than what I have quoted that I've been able to refer to. I'm just making a quick note. Paragraph 58 of His Honour Judge Clark's judgment relates again to the mother's cannabis use. The mother does not accept that cannabis use is a problem. Well, and that's it, and refers to it as a medication. Well, my client's moved a long way from that. This was something some 8 to 9 months ago. She's now abstained from cannabis use. She's in a completely different position to where she was at that stage. The judge also says at paragraph 60 that he finds the evidence provided by the local authority, the psychiatrist, and the independent social worker and guardian to be true and accurate. Well, the psychiatrist is the person that says that there is a link between the cannabis use and her mental health. And I would submit that if that was true then, and my client has now subtracted the issue of cannabis from the equation, then it only leaves her mental health, that she has been addressing and has addressed, and therefore it can be true to say that her mental health has improved somewhat. There is also criticism of my client not taking Manha to school during her reception year, and that was something which my client has reflected upon and suggests that maybe she could have tried a bit harder. But she does remind the court it wasn't compulsory for Manha to attend, but she's reflected upon it. She's addressed it in her statement that she could have been a bit more not forceful, maybe a bit more decisive in the decision-making process for Manha. Judge Clark talks about the home where Manha was raised, paragraph 64. Your Honour, I believe I've addressed that. Now the mother lives independently. She is no longer exposed to an atmosphere that was proving to be hostile and difficult for Manha. So that's being done. Your Honour, so on that basis, my submission is that my client has addressed the issues raised by His Honour Judge Clark within her statement and hopefully within the submissions that I have provided to the court this afternoon. My client is extremely concerned about Manha's recent behaviour. She's extremely concerned about the fact that she has the sexualised behaviour is a huge concern to her. And my client believes that, if anything, Manha really misses her. She's asked, and she wants to know, and this is Manha, wants to know why contact isn't taking place. It shows that there is a requirement, a need, a request to have a relationship with her mother, and that's something that my client seeks to have. My client is of the view that the current foster placement and even a local